Arraignment. Arraignment is a stage in a criminal proceeding where the accused is formally informed of the nature and cause of the accusation against him or her. It is when the information or complaint is read in an open court and the accused is asked to plead guilty or not guilty.
What is the purpose of arraignment? First is to inform the accused of the exact charge filed. Second is to give the accused the chance to plead guilty or not guilty. And third is to protect the right to due process by ensuring that no one is tried without knowing the accusation.
Steps of the arraignment. First, the case is called in an open court. Second, the accused appears personally and is assisted by a lawyer. Third, the clerk of court reads the information or complaint in a language known to the accused. Fourth, the judge asks if the accused understands the charge.
You're goddamn right I did!
Fifth, the accused enters a plea either guilty or not guilty.
Private to us, who wishes to enter a not guilty plea.
Sixth and the last, the plea is recorded and the case is set for pre-trial if the plea is not guilty.
Rights of the accused during arraignment. Number 1 is the right to be present and personally hear the charges. Number 2, the rights to be assisted by counsel. Number 3, rights to be informed of the nature and cause of the accusation. And number 4, the right not to plead until properly informed. And number 5 is the right to enter a plea voluntarily and intelligently.
All rise. The Honorable Judge of Branch 12, Regional Trial Court of Escalante presiding.
Let's pray the economical prayer of the court. Please be seated. Clerk of the court, call the case.
Criminal case number 67890, People of the Philippines versus Ricky Allen Francisco for rape under Article 266A of the Revised Penal Code.
Appearances, please.
Good morning, Your Honor. Assistant City Prosecutor Arian Perdusa for the people of the Philippines.
Good morning, Your Honor. Attorney Rosales Congulia appearing for the accused who is present.
Noted. Proceed with the arraignment.
The information reads that on or about October 12, 2025, in the city of Escalante, the above-named accused, Ricky Allen Francisco, did then and there willfully, unlawfully, and feloniously, of carnal knowledge of AAA, a minor of 15 years of age, against her will and consent, in violation of Article 266A of the Revised Penal Code. Accused Ricky Allen Francisco, do you understand the charge against you?
Yes, Your Honor.
How do you plead? Guilty or not guilty?
Not guilty, Your Honor.
Let the plea of not guilty be entered into the record.
Your Honor, may we request that the case be set for pre-trial and trial days.
Granted. The pre-trial is set on October 25, 2025, 9 a.m. The prosecution is directed to prepare the pre-trial brief and witness list. The defense is likewise ordered to submit its pre-trial brief within the period provided by the rules. Ricky Allen Francisco, you are reminded that you must appear all hearings. Failure to appear may result in the issuance of a warrant for your arrest. Do you understand?
Yes, Your Honor.
Very well. The court is adjourned.
All rise.
What is pre-trial? Pre-trial is a procedural stage in a criminal case held after arraignment and before trial, where the prosecution and defense compared to consider possible agreement, stipulation, and simplification of issues.
What is the purpose of pre-trial? First is to simplify the issues for trial. Second is to mark documentary evidence and consider stipulation of facts. Third is to discuss plea bargaining and possible settlement. And fourth is to avoid unnecessary delay and ensure a speedy trial.
Steps or procedure during pre-trial. Based on Rule 118 of the Rules of Court, Sections 2 to 4, and Standard Court Practice. First, setting of pre-trial. After arraignment, the court sets the pre-trial date within 30 days. Second, pre-trial conference. The judge, prosecutor, and defense counsel meets to discuss the possible plea bargaining, the stipulation of facts, the waiver of objections to evidence, the markings of evidence for both parties, the simplification of issues, and proposed witness list and trial dates. Third, pre-trial agreement and order. The results of the conference are written in a pre-trial order, signed by both parties and approved by the judge. This order binds the parties and controls the course of the trial.
Rights of the accused during pre-trial. So under the 1987 Constitution and the Rules of Court, the accused retains full constitutional rights including number 1, the rights to counsel. The accused must be represented by a lawyer during pre-trial under the Section 1, Rule 115. Number 2, the right to due process. The accused cannot be forced to admit guilt or make stipulations without consent. Number 3, the right to be informed of the nature and cause of the accusation. So any changes or agreements must be explained clearly. Number 4, the rights against self-incrimination. The accused cannot be compelled to testify or make statements that may be used against him. Number 5, the right to speedy trial. The pre-trial helps ensure cases are resolved promptly. And number 6, the right to confront witnesses. The accused must know who the witnesses are and may object to evidence during the trial.
All rise. The Honorable Judge of Branch 12, Regional Trial Court of Escalante, presiding.
Let's pray the ecumenical prayer of the court. Please be seated. Call the next case.
Criminal case number 67890, People of the Philippines versus Ricky Allen Francisco for rape under Article 266A of the Revised Penal Code. This is set for pre-trial today, Your Honor.
Appearances, please.
Good morning, Your Honor. Assistant City Prosecutor Arian Bautista for the people of the Philippines.
Good morning, Your Honor. Attorney Rosales Regolla for the accused who is present.
Noted. Let's proceed with the pre-trial conference. Counsel, for the accused, is your client willing to enter into a plea bargain?
After consultation, Your Honor, the accused maintained his plea of not guilty and does not wish to plea bargain at this time.
Noted. Proceed.
Your Honor, the prosecution marked its exhibit. Exhibit A, the medical certificate of the victim. Exhibit B, the sworn statement of the victim. And Exhibit C, the birth certificate of the victim.
Exhibit admitted. Defense.
The defense will mark its exhibit as follows. Exhibit 1, affidavit of the accused. Exhibit 2, barangay certification showing the accused residence on the date of the incident.
Noted. The markings are properly recorded. Are the facts both parties are willing to stipulate to shorten the trial?
Your Honor, we stipulate that the accused and the victim are resident of the same barangay.
We agree, Your Honor.
Stipulation noted. Now, what are the remaining issues for trial?
Your Honor, the main issue, Your Honor, is whether the accused committed the act of rape as alleged of the information.
Yes, Your Honor. And whether the sexual acts was consensual or not.
Very well. The issues are duly noted. The case is set for continuous trial on November 17, 2025. Both parties are directed to submit their pre-trial brief and witnesses list to the clerk of the court. Mr. Francisco, you are reminded to attend all trial dates. Failure to appear may result in the issuance of the warrant of arrest. Do you understand?
Yes, Your Honor.
Good. The pretrial order shall be issued summarizing today's proceeding. This pretrial is hereby terminated.
All rise.